Long before anyone carved laws into stone or argued over them in court, human societies were already obeying rules they had never agreed to out loud. This is the part most people get wrong. Law did not begin as a brilliant invention by kings or philosophers. It began as a quiet habit, born from survival and reinforced by memory, repetition, and social pressure. Early human groups had no police, no judges, and certainly no written codes. Yet they knew exactly who could hunt where, how food was shared, and which behaviors would get someone stared at, shunned, or worse. Anthropologists studying hunter-gatherer societies have noticed something revealing rules emerged naturally wherever people depended on one another. If someone hoarded food during a famine trust collapsed. If someone ignored mating customs or territorial boundaries, violence followed. Over time, communities learned that predictability mattered more than strength. Customs became expectations, and expectations hardened into rules. No one announced them. They simply spread like an unspoken agreement that life worked better this way. What happened next is the twist nobody expects. These early rules were not enforced by force, but by reputation. Memory was the courtroom. Elders remembered who broke taboos. Stories carried warnings further than punishment ever could. A person who violated custom did not just face anger, they faced exclusion. And for early humans, exclusion was often a slow death. Law in its earliest form was less about justice and more about belonging. This fragile system almost worked until societies grew too large. As groups expanded, memory failed. Strangers appeared. Reputation weakened. The old customs could no longer keep order among people who did not know one another personally. History quietly took a left turn here. The problem was no longer bad behavior. It was scale. And solving that problem would change law forever. Once societies grew beyond villages and campfires, memory could no longer carry the weight of order. Strangers filled streets. Trade crossed distances no elder could track. This is where law stopped being personal and started becoming theatrical. Rulers realized something unsettling. People obeyed rules more reliably when those rules looked permanent, ancient, and slightly frightening. And so law acquired costumes, crowns, temples, rituals, and eventually stone. The earliest written legal codes appeared in Mesopotamia around 3000 BCE, not because people suddenly became fair-minded, but because cities needed consistency. The Code of Ur-Nammu, and later the Code of Hammurabi, did something revolutionary and deeply human. At the same time, they froze decisions in writing. Hammurabi famously claimed his laws were granted by the gods, a clever move that discouraged debate. After all, arguing with a king was risky. Arguing with divine will was pointless. This is the twist nobody expects. Law did not become sacred because it was just, but because sacred law was harder to challenge. These laws were not gentle. Punishments varied sharply by social class, and justice was often less about morality than order. Yet something remarkable happened. By writing laws, publicly rulers accidentally limited themselves. If rules were carved in stone for everyone to see, people could notice when rulers broke them. Law became both a weapon of power and unintentionally a mirror held up to it. Dates mattered now. Contracts recorded time. Property had boundaries. Courts emerged not to ask what felt right, but what had been written. Law gained authority not from memory or reputation, but from permanence. Stone tablets could not forget, exaggerate, or forgive. They simply existed. But rigidity has consequences. Fixed laws could not adapt easily to new situations. As societies evolved, people began to ask an unexpected question: what if the law itself was wrong? That quiet doubt would eventually give law a voice and allow it to argue back. Once laws were written down and placed on display, people began doing something subtly dangerous. They read them closely. This is where law learned to argue back. In ancient Athens, citizens did not just obey laws. They debated them loudly, publicly, and often passionately. Courts became theaters where persuasion mattered as much as facts, and where ordinary people, not kings, decided outcomes. Law was no longer a divine monologue. It was a conversation, sometimes an unruly one. The Romans pushed this transformation even further. By the 1st century BCE, Roman jurists were treating law almost like a science. They categorized it, refined definitions, and argued over intent versus outcome. This was not abstract philosophy. It was practical survival for an empire stretching across continents. Rules had to apply to citizens who would never meet, and cultures that shared little in common. Roman law introduced ideas that still feel modern legal personhood contracts as mutual obligations, and the notion that even officials were subject to the law. This is the part most people miss. Law did not become fair overnight, but it became discussable. With discussion came specialists. Lawyers emerged not as heroes, but as translators between rigid rules and messy human behavior. Judges interpreted rather than merely enforced. Philosophers like Aristotle asked whether laws should serve power or virtue, while later thinkers wondered whether unjust laws deserved obedience at all. These questions were unsettling, especially to rulers who preferred silence. The consequence was profound. Law began shifting from commands issued downward to principles argued sideways. Precedent mattered. Reasoning mattered. A bad law could be challenged, revised, or quietly ignored. Law gained flexibility, but also complexity. It could now evolve, but it could also stall, confuse, or contradict itself. As law grew smarter, societies grew more ambitious. The next challenge was no longer how to govern citizens, but how to regulate strangers across borders. And once again, history prepared another unexpected turn. Once law learned how to govern citizens, it faced a problem it was never designed for: how to control people who owed no loyalty to the same ruler. Trade ships crossed oceans. Empires collapsed. New nations appeared, often arguing over borders drawn by exhausted negotiators. Law had to stretch beyond kings' cities and even languages. And strangely enough, it tried to do so without teeth. Modern legal systems grew from this tension. In the 17th and 18th centuries, thinkers proposed that law could rest on shared principles rather than shared rulers. Ideas like natural rights, social contracts, and constitutional limits emerged not from optimism, but from exhaustion. After centuries of religious wars and absolute monarch societies wanted rules that could restrain power without constantly spilling blood. Constitutions turned law into a promise, not just a threat. International law was the boldest experiment of all. Treaties attempted to bind nations that could simply walk away. Courts formed with no armies to enforce decisions. This sounds naive, and sometimes it is. But here is the twist nobody expects. These fragile systems work more often than they fail, not because they are powerful, but because predictability still matters. Nations obey rules for the same reason. Early humans followed customs. They fear isolation more than punishment. Today, law governs digital spaces, invisible transactions and disagreements between people who will never meet or even know each other's names. It is slower than technology, more cautious than culture, and perpetually behind the present moment. Yet it endures. Law was never a perfect design. It is a long conversation across generations, full of revisions, arguments, and uneasy compromises. And the real mystery is not that law sometimes fails, but that against all odds, humans keep choosing to believe that rules can outlast power.